Good morning. It is Thursday, July 12th, 2012, and I'd like to thank you for joining us today for this webinar from the League of Minnesota Cities. I'm your moderator, Joyce Hottinger, Assistant Director of Human Resources with the League of Minnesota Cities, and I'm joined by today's presenter, Scott Lepak, attorney with Barna, Guzy, and Steffen. Scott has been representing employers on labor and employment matters since 1987 and is among the leading labor attorneys in the state of Minnesota on matters affecting local government and nonprofit agencies. He is also the city attorney for the cities of St. Francis and Becker, author of a treatise on the Minnesota Public Labor Relations Act available on the Minnesota League of Cities website, editor of the Minnesota Public Employer Labor Relations Association newsletter, a member of the Metro Area Chief Labor Negotiators Roundtable, and provides labor and employment law counsel for the League of Minnesota Cities. He is a frequent lecturer on labor and employment topics, and we are delighted to have him present today on city employees and off-duty conduct. Scott's presentation will provide some guidance when off-duty conduct is illegal, unethical, or harms the reputation of the city. It's often hard to know whether or not the city can discipline for that behavior. Off-duty conduct is a tricky and ever-changing area of employment law. There are issues associated with freedom of speech and expectations of privacy that must be weighed against the legitimate interests of the city. After the presentation, if time permits, we will turn to questions we have received in advance of this webinar. You may also submit questions during the webinar. If you have a question you'd like to ask, please send it to lmcwebinar@lmc.org. That's lmcwebinar@lmc.org. Also, if you have any technical difficulties during the session, you can email lmcwebinar@lmc.org or call 1-800-925-1122. So let's get started. Scott?
Thanks, Joyce. Welcome to today's webinar. Oh my goodness, it's my very first webinar, so I'd like to give a live shout out to the audience in the room next door upstairs who are joining me for this very first webinar that I'm giving. This is going to be kind of an interesting experience for me. I've heard throughout the course of my life that there's a lot of people that would not go across the street to listen to me. Well, now you don't need to. I'd also like to thank Joyce for not saying that I'm an expert on off-duty misconduct, because that would have been wrong and inappropriate. I guess I should start out by saying if you're in the public sector and you're a public employee and you want to find out what you can and can't get away with, you've probably come to the right place. If you're in the private sector, this stuff is probably going to apply to you as well, but when we get to the First Amendment, you can go out for a smoke unless it's prohibited in your work site. If you're here because you want to find information about little men's clothing and you went to LMC, this is the wrong website, but please don't leave. It might affect my ratings. The working title for our webinar today is Stuff That Will Get You Into Trouble. Off-duty misconduct. The first thing we always talk about when we're talking about off-duty misconduct is what can we do, what can't we do? We all want to know what off-duty conduct we can do and not get in trouble, and what we can't do. If we're boring and bossy and we don't care about that, we still want to know what the rules are so we can tell everybody else what to do. Of all the states that I have lived in, Minnesota is probably clearly the leader in telling you what you can and can't do. Louis Black, one of my favorite comedians, had a stand-up routine where he talked about going to a bar in New York. And it got near the end of the day, end of the night, and he said, gee, talking out loud, should I have another? And everybody at the bar said, well, if you have to work, I wouldn't do it. Probably not. You'll probably have a hangover and you won't feel good tomorrow. What would your wife think? He said, okay. He went to a bar in Ireland, and he asked himself the same question out loud when it came time to closing. He said, should I have another? So everybody in the bar looked at him and said, well, why wouldn't you? Minnesota, pretty clearly, is a state that likes to tell you what you should do and what you should not do. Our life's mission in the state, I think, is to make sure that nobody has any fun, and it turns out that life in the public sector is not always a box of chocolates we always thought it was going to be. On the plus side, Minnesotans are fairly cheerful in telling you what you can and can't do. So if you're looking for lists, yes, no, that's what we've got for you today. Oh, actually, when we talk about the area, we're talking about the trick to identify what is off-duty misconduct, what's protected activity. We're looking for a line. Where does this line exist? I always think about a client that I had. When we went from old vacation and sick leave policy to a personal time off system, we had a lot of discussion on how that was going to apply. We explained it was a single time off plan that was super great. It was flexible for employees. You were going to just absolutely love it. We put it into place, and because the employer was a public employee, the first thing we did is we started developing forms. And the first thing we put on the form is, what's the reason for your absence? Well, one of the first responses we got back was an employee that put down, none of your beeswax. I love that. That got to be one of my kudos or credos in life. What we're talking about today is something, is it of legitimate concern to the city, or is it none of your beeswax? Is that a nice bright line? Well, no, it's not. If it was, the webinar would be 6 minutes long, and I would not be able to buy the boat that I'm looking at by charging clients who are dealing with off-duty behavior. One of the great lines in the PowerPoint materials we put together, actually my law clerk put together, indicated that, I got to quote this from her. She said, this area involves a balance in a murky area of law with varying precedent. Now think about that. When you charge by the hour, it doesn't get any better than that if you're a lawyer. Truthfully, nice bright lines tend to be pretty blurry when we start talking about lawyers are in the room. Again, my favorite line when we talk about what's the clear-cut answer, what's the bright line, came out of a frustrated United States Supreme Court Judge Potter Stewart back in 1964. And they were arguing about what was hardcore pornography. And he listened to all the arguments. It was pretty evident that he was struggling to come up with a definition. And what he wrote, and here's the bright line that we've got, I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthanded description of hardcore pornography. And perhaps I could never succeed intelligently doing so. But I know it when I see it. Wikipedia talks about that phrase as a speaker attempting to categorize an observable event or fact, although the category is subjective or lacks clearly defined parameters. That's actually a pretty good description of what we're doing here with our off-duty misconduct. So there often is not a clear-cut answer. That gives us an hour webinar on it. So when we start talking about what is off-duty misconduct, 9 years ago, there was a Berkeley law professor, Steven Sugarman. He wrote a really interesting article detailing examples of where employers in both the public sector and the private sector disciplined or terminated employees for behavior that took place off the work site. And some of these examples are really interesting. And I would note and thank the league for putting in little symbols on the side that really make this an enhanced presentation. The University of Alabama fired its new football coach after it was reported that he partied with strippers when he was in Florida for a golf tournament. Well, that'll get you fired. San Francisco Chronicle dismissed a technology reporter after he was arrested while protesting the war in Iraq on his free time. A Lockheed employee claimed he was punished by his employer because of jokes he told at a private retirement party honoring a fellow coworker. Chicago Tribune forced the resignation of, this is nationally known columnist Bob Green after it was disclosed he had a sexual relationship with a young woman he had earlier featured in a column. The dean of students at a Catholic high school was forced to resign after his name and photo were found on sexually suggestive websites related to homosexuality, motorcycles, and leather. TBS adopted a policy of hiring only non-smokers. Commercial airlines suspended pilots who smoked marijuana on their days off. Walmart fired 2 sales associates who violated the firm's ban on dating between employees who work in the same store. Coors Brewing offered economic incentives if you pledge to wear seatbelts whenever you drive. The Air Force brought court-martial proceedings against officers who committed adultery. Professional sports leagues disciplined people, players and owners, for gambling and for associating with gamblers. And the Marines, briefly, announced that they only wanted recruits who were single. Remember, that was 9 years. Not much has changed in those 9 years. It's a pretty interesting list when we talk about that laundry list. I don't know if we have the technology, but raise your hand at home if you agree with every single one of those issues as a statement of an instance where somebody should get in trouble. Okay, some of you raising your hands, not everybody. So we're going off the premise that not everybody agrees with everything in that list. In the 9 years since, we've come up with some new stuff. We got the University of Arkansas. Again, we're talking about football coaches. This is Bobby Petrino. He didn't disclose an inappropriate relationship with a female employee as national polls hotly debated which one of his mistresses was most attractive. In this instance, Bobby actually had gotten in trouble. He got in a motorcycle accident, and one of the individuals that he didn't disclose was on the back of the motorcycle. Maybe he forgot she was back there. They found out, well, it was one of his mistresses, and then it found out he had another extra mistress, and she just happened to be on the payroll. So does that get you in trouble? The University of Arkansas says it does. Sherry Sandusky, of course, has got the famous conviction of sexual assault while associated with the Penn State football team. In 2012, the Putnam County Sheriff's Department instituted the policy that says employees of the Putnam County Sheriff's Department are not allowed to date or marry one another. In the event employees wish to date one another, one of the parties must abandon his or her employment with the Putnam County Sheriff's Department. That sounds like a sheriff that's frustrated because he can't find Bo or Luke Duke whenever he wants to. When we talk about governing off-duty misconduct, the issue gets to be where do we regulate this conduct? So we're talking about where. Where do you do it? You can regulate it in an employment contract. There's much less of a distinction in the public and private sector, by the way, when we start talking about employment contracts. If you're operating under a written employment agreement, you've got an opportunity to put in regulations, standards, requirements related to off-duty conduct. They often state things like moral turpitude is prohibited. Whenever that pops up, I always have to look up and see what moral turpitude is. It really means depravity. In this instance, whether you've got off-duty conduct, it's within the realm of potential discipline. That simply gets negotiated. In the public sector, obviously, in exchange for the meager salary and the abuse that you're certain to take once you get appointed, we would like you to promise to always be good. This is your labor contract negotiations. Okay, great. You agree to this. We're going to put in all kinds of off-duty conduct that you can't do, and sign here. And then the person signs, and we say, okay, we're going to take you away and take a small brain sample, so then they move on. So here you've got a contract that applies. Bobby Petrino's case actually had one of those clauses in it. The contract says that the university had the right to suspend or fire the coach for conduct that negatively or adversely affected the reputation of the university's athletic programs in any way. So that's the contract clause. You want to put that in yours? If you're an employer, well, then if anybody gets in a motorcycle accident with one of their two mistresses and lies about it, then you can fire them too. Beyond the employment contracts, we can also talk about off-duty conduct that is simply beyond the pale. One of the examples that I've put in the program is we could talk about an employment agreement stating that a violation of a criminal law or a conviction of a felony involving honesty, death, morals, or drugs is grounds for dismissal. When we start talking about convictions, obviously that gets to be pretty farther down the road than most employers. They want to get rid of somebody before you get to the conviction, but we do have some issues related to that in Minnesota that we'll talk about in a little bit. So we talk about contracts as a place where you can regulate off-duty conduct. And as a practical matter, in employment contracts in Minnesota cities, they tend to be limited to the big hitters, the city managers, the administrators, the high-level department heads. They don't apply to the lower-level schlubs like the city attorneys. So, when we talk about another area where we can govern off-duty conduct, we look at union contracts. Union contracts can provide the grounds for regulating employees' off-duty conduct. The typical language of a public employment contract prohibits discipline unless just cause for such discipline exists. Union contracts can also expand on that and talk about specific examples of misconduct leading to discipline. So if you've got a union contract, for better or worse, that's the source of where you can discipline. When you're talking about disciplining for off-duty conduct, union contracts that cover the union employees are where you have to find the basis for any action that you're going to be taking. So we've got employment contracts, we've got union contracts. Most often when we talk about off-duty conduct being regulated, we talk about them being contained in the city's policies. The city's policies apply to non-union employees. Union employees may also have the city's policies apply to them if the policies supplement the union contract. I also would note as a city attorney, I have included in terms of conduct elected officials, including city council members, mayors, in our policies, and that the mayors and the council members voluntarily agree to be governed by that off-duty conduct. So I know we're talking about employees today, but that is also an area where you can broaden it out. Basically, if you've got a city policy, you've got a union contract, you've got a written contract, the difficulty you have is writing down all of the things that are prohibited and that employees can get in trouble for. Anybody that thinks that they can write down every single thing that an employee can get in trouble for seriously underestimates the ability of employees to get in trouble for things that they should get in trouble for, but you didn't remember to write down. I guess the example I would give you in this is we all know life has really been regulated and explained by Seinfeld. One of the great episodes in Seinfeld involved George Costanza, and George Costanza actually got in trouble for sleeping with the cleaning lady at night at work. And of course his boss found out about it and brought him into, I can't remember if it was a termination or a lower level of discipline, I think it was a termination. And he told George, you know, this is the problem and this is what we're going to do to you. And George says, well, if I had known you couldn't do that, I certainly would have done it. Thanks for explaining to me. I won't do it again. But truthfully, if I had known, was that wrong? It actually gets to be one of the Seinfeld lines that you hear from here to eternity. So you can define it. You can add every single thing that you can think of. And an employee is much more creative than you are as a drafter, and they will find something that's not written on there that clearly is offensive and you still want to discipline them for. So it gets to be a trick when you write where you can discipline. You can write what is prohibited, but you still need to have additional flexibility when you talk about what is misconduct. Basically, when we talk about the limitations on conduct that you can regulate, we talk about the common use of a just cause standard or similar misconduct standard in veterans' preference. This obviously involves considerable leeway in interpretation by an outside arbitrator. This gets us really back to our Supreme Court Justice Potter Stewart and his frustration with trying to figure out what pornography was. And he said, I know it when I see it. Well, basically, when we talk about I know it when I see it in the public sector, in the unions, we're talking about just cause. Basically, just cause is whatever the supreme decider thinks is bad enough to get you in trouble. Who's the supreme decider? Well, my initial theory when we started talking about who should decide what is just cause, back before I found out that there's all kinds of standards applying, is that if I had to pick somebody that would decide what is just cause to get you in trouble, who do you pick? Well, obviously you pick your mom. If we could have employees hired along with their mom, I think we would have absolutely no problem with applying just cause standard. You observe the conduct, you're the mom, the punishment is quick, it is just. Playing Angry Birds instead of filling out your WH-382 form, your mom's going to say, I taught you better than that. What are you doing? Smack, side of the head. I'm going to tell your father when you get home. The problem we've got with this as a standard is moms, by and large, don't want to spend any time with their kids. They certainly want to go to work with them. The other problem we've got is what do you have if you have a mom that has more than one kid? Actually, I've run this past my mom, and she said, well, that's easy. The mom always knows which kid you have to go to work with and which one you can leave go by themselves. Since we can't use moms in this area, when we talk about who decides just cause, we've got the supreme decider that we call an arbitrator or a panel. It's an outside neutral. They're the person that decides what is the stuff that will get you in trouble. I always tell people that, and they laugh, and I say, cases might get decided on what an arbitrator had for breakfast, whether they stubbed their toe on the way in the door or whether they had a fight with their significant other on the way out the door or right before the ruling. They laugh. I'm not kidding. Honest to goodness. I can't remember which arbitrator it is, for example, but they've noted that they're not particularly offended by pornography. So if as a public employer you've got a case that involves that specific conduct and you've got an arbitrator that is not bothered by it whatsoever, well, then guess what? Just cause doesn't decide the case, or just cause is not going to uphold discipline or discharge in that case because the arbitrator doesn't view it as simply that bad. So, just cause. When we talk about just cause, in an effort to make not just whatever anybody wants it to be, or that their mood takes them to, we tend to use some factors to determine what is just cause. And basically, these are cases, this comes out of a famous arbitration case called Enterprise Wheel and Carol Doherty. And actually, I like this because it actually takes something that is as subjective and ambiguous as you possibly can and applies some standards to it. So what is just cause? Well, number one is, did the employer give the employee forewarning or foreknowledge of the possible or probable disciplinary conduct? An alternative is this so obvious that you should already know it? This is the George Costanza rule. This is the one where George leaped on and said, hey, I didn't know this was a bad idea. So that's the first one. When we talk about just cause, you got to meet that. Actually, you've got to meet all of these. Number two, was the employer's rule or managerial order reasonably related to the orderly, efficient, and safe operation of the employer's business and the performance that the employer might properly expect of the employee? Remember those two standards because we're going to talk about them a little more in depth. Three, did the employer, before administering discipline to an employee, make an effort to discover whether the employee did the deed? And four, was the employer's investigation conducted fairly and objectively? Five, at the investigation, did the final decision maker obtain substantial evidence or proof that the person was guilty as charged? Six, has this been applied in an even-handed and non-discriminatory fashion to all employees? And then seven, was the degree of discipline administered by the employer in a particular case reasonably related to how serious it was, and then the employee's record? So those are the seven standards, the seven factors that you apply to figure out if just cause for discipline exists. In this instance, where we're talking about off-duty misconduct, the focus is really on factor one, whether there was a rule in place, and factor two, was the rule reasonably related to the orderly, efficient, and safe operation of the employer's business and the performance that the employer might properly expect of the employee. So we take a look at these two factors when we're talking about off-duty misconduct. Typically, the first thing we're talking about when we're looking at off-duty misconduct that we want to regulate is whether we can establish as an employer the connection between the conduct and the potential or actual damage to the company's reputation and problems in a relationship with the other employees at work. What's the hook? What's the connection that we've got? The National Academy of Arbitrators test, they give us a four-prong test that requires an employer to establish only one of the following. One has got to be this misconduct involves harm or threats to supervisors, coworkers, customers, or others with an actual or potential business relationship with the employer. The misconduct could seriously damage an employer's public image. The misconduct reasonably makes it difficult or impossible for coworkers, customers, or others with an actual or potential business relationship with the employer to deal with the employee. Or, finally, the employee makes off-duty public attacks on the employer's supervisors or the employer's product. I would note that when we talk about this four-prong test, this is a test that Christine Verploeg put together in a William Mitchell Law Review. For those of you that do a fair amount of this work in the public sector in Minnesota, Professor Verploeg is one of our existing arbitrators, and employers tend to use her a great deal if given the opportunity. So if you have Chris as one of your arbitrators, and you've got an off-duty conduct case, she's just giving you a roadmap of what you need to prove. Besides Chris's test, or the National Academy of Arbitrators test, we've got an alternate four-prong test. And it's actually pretty much the same, but it's worded a little differently. In my world, truthfully, I take a look at my case that I'm trying to put together, and whichever test fits my case, I use that one. So that's high-level legal thinking on my behalf. So. Number one is the behavior harms the employer's reputation or product. Now, obviously, this is a pretty highly subjective test. To the extent the conduct is reported in the press, the grievance is identified as an employee of the city, the case for discipline or discharge is really strengthened, particularly if a serious crime is involved. So we talk about the city's reputation or product. And then, of course, we get into this debate as to what the city's reputation or product is in the first place. So we tend to not use that prong as much as we can in arbitration, because then we start talking about what's the city's reputation anyway. The second one is the behavior renders an employee unable to perform his or her duties or appear at work. If the conduct is closely related to the grievance responsibilities, a nexus exists. Nexus means the hook that we're looking for. The conduct example they give here is dismissal of the security guards appropriate for off-duty theft. Good idea. Off-duty conduct has to affect the work performance. In this instance, my classic example in this is simply, it happens to me periodically, not me personally, but clients throughout the course of a year. You wind up with employees that get chucked in the clink. And if you get chucked in the clink and you can't go to work, well, guess what? They're pretty hard to perform his or her duties or appear at work. Now, some of them think that doesn't really affect their job performance that much. I can take care of it. I've got a dime here. I can make a call and take care of some of my work stuff. But typically, if they don't appear, that is AWOL. Number 3, the behavior leads to refusal, reluctance, or inability of other employees to work with him or her. This is a prong in this test that I've got a little bit of heartburn trying to apply, because one of the things we always have to be careful of when we talk about treatment by other employees is whether the other employees are acting against this employee for discriminatory or an improper purpose. So if they're picking on an employee because of protected status, we better not be, as a city, applying this particular standard. So you can document objections to coworkers to persuade the arbitrator to discharge the employee. Actually, that's good to do, because one of the things, if you're a union rep and you're trying one of these cases, you want to bring in all of the employees to say this coworker does not need to be discharged because they're great. So from the perspective of a discharge case, if you can get the coworkers to say, we don't support this person, or that's not how we do things. If the grievance reinstatement poses a threat to the safety of other workers, discharge will likely be supported if you get the right arbitrator. We always have to add that. And they had something for breakfast that didn't irritate them. Finally, the alternate 4-prong test that we're talking about on this alternate test is the off-duty conduct undermines the ability of the employer to direct the workforce. And basically, we don't have any examples listed in this, but it's one where simply, if you bring them back, it's all chaos and we can't get anything done. So when we start talking about these prongs, that's basically the general standards that we have to establish. What we then have to take a look at is we also have to look on the significant limitations that we've got simply on regulating off-duty conduct. When we talk about regulating off-duty conduct at the city level, the first thing we should be looking at is First Amendment protection. It's listed right away in the amendments to the Constitution, and freedom of speech is the first thing that pops out of anybody's mouth in a city when you want to take action against them for something that they've said. And actually, the first case, I didn't put it in our materials, but I think I'd like to at least make a note of it. When we talk about the First Amendment cases involving public employees and their freedom of speech, there's a case called Garcetti against Ceballos from 2006. And it's a United States Supreme Court case. And basically, in that case, it was an assistant district attorney, I believe, and he found out about a search warrant affidavit within his office, and he did his own personal investigation on it, even though it wasn't his case, and came up with some serious objections and concerns about the validity of the affidavit that supported the search warrant. He griped about it internally. They told him to go away and go back and work on his own cases. Well, as a matter of course, and you can probably guess, he winds up testifying for the defense in the case. So it's the assistant district attorney is testifying for the defense. That doesn't make his boss all that pleased. And the employee then says, hey, you're starting to take action against me because of this action. And his action is protected free speech. It goes to the United States Supreme Court. The United States Supreme Court says, well, I tell you what, if it's within the course of your duties as a public employee, then it's simply not covered by the First Amendment. So if you're doing your duty, even if it's badly done, if it's within the scope and course of your duty, it's not First Amendment. You don't worry about that. So that tends to be the seminal opinion when you talk about what's the First Amendment protections afforded to public employees. But because we're talking about off-duty conduct, we typically don't have that as a concern. But note out of that case that not all First Amendment protection automatically attaches to everything that public employees do. When we're looking at off-duty conduct, we have to balance the employee's rights to freedom of expression on matters of public concern with employers' interest in promoting efficiency of public services. That's the balance. It's a balancing test. Again, a little more gray area. The balance is in favor of constitutional protection, except when an employer shows that some restriction is necessary to prevent the disruption of official functions or to ensure effective performance of the employee. So you're taking a balancing test. You're not getting a bright line out of this, but basically when we're looking at the conduct, we're also looking at content, context, time, manner, and place of employees' expressions. Conduct that rises to the level of misconduct may be just cause for termination, but never for termination of the right to free speech. You can say whatever you want. You just can't say whatever you want and work here. That's the buzzword on our lessons from the First Amendment. So the real reason I'm sure everybody checked in today was to talk about limitations on regulating off-duty conduct. And it's social media. Social media is one of the great things that has developed for both people who like to spend their entire lives on computers and lawyers. Social media, I gave this speech, quite frankly, back in 2008, and looking back, that was pre-social media. I think of that as the golden age of employee discipline. Now that we've got social media, we've got this whole new area of off-duty conduct that we have to worry about. And my general response when people would call and say, what's the standards that apply to off-duty conduct and social media? My response has always been, well, I tell you what, it's the exact same conduct that you can either regulate or not regulate if it's face-to-face or if it's done by a spoken word. And I thought I was pretty smart in just giving that glib, short answer, and it doesn't require a lot of research, and I can go do something else. But as I discovered, life develops, and social media is an area where people write things, create records of things. You're able to prove things existed that you never can establish when we're talking about a spoken word or a conversation. So it creates a record. But more significantly, what it does is social media is established, in my experience anyway, a forum for people to put things down that they would never tell anyone else. It is the most amazing phenomenon that I've ever seen in my life. I don't Facebook, I don't understand any of this stuff, except to the extent that it gets posted and I get my hands on it for purposes of misconduct cases. Really, I think that the general standard of social media occurred, Bill Belichick. If you're a football fan, Bill Belichick is the head coach of the New England Patriots. Bill is viewed as something of a old school nasty extremist, and they told Bill that his players were tweeting. And he said, well, what's that? And they said, well, and they explained to him what tweeting was, and Bill decided, well, he didn't like that at all because then they're letting out secrets. He said, okay, I'm going to address the team on social media. He came in, he gathered the entire team in an auditorium, came up in front and said, here's my policy on social media. I don't want any of you on MySpace or Facebook. And that's all I got to say. And he walked away. So nobody on the New England Patriots is on MySpace or Facebook. When we start talking about social media, obviously employers would like to say, stay off that stuff. Unfortunately, that's not really practical. It doesn't occur, and in instances where it involves protected conduct, you can't keep employees off of social media. So when we talk about social media, we're talking about something that we recognize is existing. We've got to move on. We've got to live with it. So the question gets to be, how do we regulate? Can we regulate anything that occurs within the social media area? Typically, when we talk about social media, the people that are taking a look at this now is the National Labor Relations Act. They're the folks that are in charge of the private sector labor laws. And I view it as kind of funny because the National Labor Relations Board, they're kind of a World War II group. They interpret language from World War II. They go back to the 30s. They are struggling with social media. And it's funny, I think they're now on their third or their fourth general counsel memo on how to deal with social media and expression of rights under the federal labor laws. And so if they're on 3 or 4, I'm starting to view their memos as coming out about as frequently as you get those emails on people of Walmart. So they're going to just keep coming out because people are going to keep coming up with social media concepts that are going to get them in trouble, and we're going to have to figure out if it's okay or not. Because we're talking about cities in our webinar today, we're not specifically subject to the National Labor Relations Act or its interpretations. The one thing that has happened, though, because our state labor law applicable to cities really does utilize the NLRA as the model for a lot of its language, we're talking about an instance where the laws, as they're stated, are pretty much the same. So when we talk about what's regulated in the state for cities, I think we need to keep track of what the National Labor Relations Board is saying when we talk about what can be social media that's regulated. So when we talk about it, we talk about Section 7 of the National Labor Relations Act, the right to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. We've got a similar provision in our state law. So that basically gets to be the starting point when we look at what's okay to regulate within social media. Concerted activity is what is regulated. It's not individual activity. It's got to be concerted activity. An action by individuals engaged with the authority of other employees, or action by a single employee trying to enlist support of fellow employees by initiating or inducing action. It does not include individual gripes, and even acts that are concerted that are outrageously disgraceful may lose their protection. So we're looking at, like we look at in the real world, is the conduct something that is being done as a collective action? Is it being done to further terms and conditions of employment? If it's simply just an individual beef, it does not have protection. We get to mutual aid and protection again. The post has to be about a mandatory subject of bargaining. The post may need to be about creating change. The general counsel, like I said, is struggling with this concept a little bit. They've got a two-step review. One, the rule clearly unlawfully, the prohibition by the employer is clearly unlawful if it explicitly restricts Section 7 protected activity. If it does not specifically restrict it, there's only a violation of a different section if employees would reasonably construe the language to prohibit Section 7 activity. So when we look about that, the rule has to be promulgated in response to union activity. If we create it, then we're in trouble. The rule has been applied to restrict the exercise of Section 7 rights. This is what the NLRB has told us. It's a lot of gobbledygook. Truthfully, what the NLRB has told us is decent language. When we put together a social media policy that prohibits some social media, we want to put in language that says, and write this down quick, it says the employer is not seeking to restrict Section 7 rights. And if you want to provide definitions, examples, or other specific guidance, you can do that. So the little blurb that we're all telling, all the lawyers out here that are doing this are telling all of our clients, if you're going to be putting together a social media policy, number one, let us look at it before you put it into place. It is something that you want to have prior review before it's in the world. Once it gets in the world, then we're in trouble. We want to have this disclaimer that says we, by this policy, are not trying to restrict our Section 7 National Labor Relations Act protected activities. Remember when our personnel policies, we always put in language that says this is not intended to create a contract. This is our new buzzword on social media policies. So there's our example for the day. This is an interesting state because we've got a law that says the Minnesota public sector labor law does not prohibit a collective bargaining agreement from including provisions related to workplace communications. You look at that and you say, well, what the heck does that mean? Workplace communications are any printed or electronic document, and it's pertaining to union business or organizing as provided under state law. When they drafted this language, they pretty clearly wanted this to be a union and employee protection. But if you take a look at the law, It appears to allow cities to regulate such conduct through negotiating restrictions and prohibitions in the collective bargaining agreements. The only problem in doing that is you need to find a collective bargaining partner that's dumb enough to enter into that if you're the city. So we talk about limitations on regulating off-duty conduct. The one that absolutely drives cities batty is that we have a law, Minnesota Statute Section 364, that prohibits cities from taking action against an individual who is charged with a crime where there is no valid conviction. So you get arrested. That's not enough to simply bounce somebody out. You can't act on a criminal conviction that's been annulled or expunged. You can't take action if it's a misdemeanor for which no jail time can be imposed. And basically, we talk about convictions in this area. Convictions take a long time to get to, particularly when we start talking about DUIs and the application of our DUI laws to off-duty employees, regardless of when the action occurs. They get pulled over for a DUI. It takes months and months, sometimes years now that we've got a big criminal controversy about our source code violations. It might be a year or two before there is actually a conviction resulting from a DUI. This law, this 364, is very frustrating when we start talking about the extent to which we can regulate off-duty conduct that is an arrest but not a conviction. And remember, out of this, we also have to talk about convictions of misdemeanors for which no jail time can be imposed. It gets to be one where they have basically put a floor on prohibiting actionable disciplinary action. And even if you get to the conviction stage, this same law, Minnesota Statute Section 364, it deals with employment and convictions. So even if you've got a valid offender that gets convicted, take a look at this law before you take any actions against this individual. What I will tell you when we start dealing with criminal activity is, A, it gets to be a real complex area. Always include your city attorney, your labor council if you've got one, right off the bat on these things because, A, it's going to be a high-profile thing, maybe. So you're going to need to deal with the PR aspects of it and the data practices aspects of it. And then you also need to dive right into when and where can you start doing your own investigation for this off-duty conduct. In criminal matters, typically you will have an instance where the criminal investigation is occurring, and the criminal investigation or the investigators may not want you to participate or do your own investigation because it's going to, quote, screw up, unquote, their investigation. And they want you to keep your hands off. So timing on these gets to be real complex. Again, what I would tell you to do is if you've got criminal activity, you've got an arrest, you've got charges, call your lawyer right off the bat. The other one, and I take this all the way back to the Putnam County Sheriff and his frustration with employee dating. There's a law in Minnesota, it's our human rights law, that says that you can't discriminate against someone based on their marital status. And marital status is not only marriage, but is in a relationship, but not married. So employer regulation might lead to human rights claims when we start talking about relationship between employees. Truthfully, I don't talk about how far back in the world I go, but my first Court of Appeals case, actually it might have been that wasn't my first case, my first Court of Appeals case, I represented a county down on the southern border, and it was a human rights claim, and it was based on the fact that I had a young lady who was an admirable performing secretary, and she worked for the CETA program, if I can go that far back with some people, and she announced to her supervisor, and the very nice lady, that she was pregnant and was thinking of getting married to her boyfriend, her longtime boyfriend, who was the father. And the supervisor, who told me, she said it because of her strong religious beliefs, told the lady, why would he marry you now if he didn't before. And obviously when the CETA program ended, the lady didn't get promoted into an open job. She filed a claim for marital status discrimination. That got to be the smoking gun in the case. As soon as the judge heard that, I knew we were in a little bit of trouble. But we wound up with a claim based on marital status. To my knowledge, that's our first marital status reported case. So remember, you can't discriminate against somebody based on marital status, and that doesn't only include marriage. There's a recent, I say recent, it's a year old now, 2011. There's no need to specifically allege a direct attack on the institution of marriage for marital status discrimination cases. What I'm trying to tell you by this is the Putnam County Sheriff would be extremely disturbed to be in Minnesota and run into these limitations that he's trying to regulate in his area. So from our perspective, we've probably got more limitations than Tennessee, so we'll move on from there. The one thing I would tell you, if you're a private sector employer and you're sneaking in and listening here, there's a statutory prohibition on regulating lawful non-work activity, and I've got the statutory site 181.938 that says you can basically smoke and drink off-site and party to your heart's content and post it on Facebook and just have fun in general. Well, that does not apply to Minnesota City. So again, private sector employees can have a lot more fun than public sector employees. So don't worry about that if you're in the cities. And what we tell you is go to town. It doesn't apply to you. Now we get to the arbitration rulings. One of the things we promised you is a list of what you can and can't do. And we still don't have our technology fixed in here. I can't see the people at home, but the group that I've got off-site here, I would like you, when we start talking about these disciplinary actions, if it has affected you as an HR professional and it's been in your city and it happens, I would like you to raise your hand if this has affected you. And actually, I want to tell you how I came about this. I grew up Catholic. I am Catholic. My parents went off to our very first thing called a communal confessional. And you go to confession back in the old school, back in the 60s, you'd go in a little room and you'd tell the priest everything you did, and then the priest would chuckle and then he'd tell you what was going to happen to you. But they adopted a new thing called communal confession, and basically it's a mass. And my folks, my mom and dad went off to one of these, and I didn't go for some reason. And they came back, and I said, hey, how did that work? And my dad said, well, it actually is pretty efficient. The priest goes up there, and we have a mass, and he said, but then we get to the halftime speech, and then the priest goes through a list of all of the sins. And if you committed that sin, you got to raise your hand. And if you did it more than once, you got to hold up the number of fingers you've done it wrong. So what I'd like my off-site group to do in the next room, if you're involved in this, I'd like you to raise your hand, and if it's happened to your city more than once, raise the number of fingers that it's occurred. If you've done it yourself, raise your left hand. So we'll have a discussion on this afterwards. So we've got some examples of where discipline for off-duty conduct is upheld. Number one, termination for placing a private part in a fellow employee's hand during off-duty birthday celebration at the local bowling alley. Yes, this was my case. Okay, I don't know if we should just leave that as it's stated. One of the things I will tell you, though, at that bowling alley, is there's some allegations that the employee prior to this had been betting, and I think it might have been a brother-in-law, don't quote me on that, but they were playing dice, and I think if you lost, you had to drop your pants and then go up to the bar and buy a round. So I think this led up to, there was some fun activity before we even got to this point. The arbitrator, Steve Beffert, and take a look at the arbitrators that uphold these, because when we start talking about dealing with discipline, the arbitrators' views on these get to be pretty interesting. So if you do this particular activity during an off-duty birthday celebration at the local bowling alley, you may get fired. That same party, that same bowling alley, it was quite a night, another employee got terminated for lying about the off-duty conduct noted above. What this employee did is they're the ones that said, well, you know what, I saw it. And then they changed their story after the termination started. And I think the story turned into, well, I didn't quite see it, or it might have been something else. And they got fired. Another one, termination for off-duty DUI where the employee is required to have a CDL. This is a City of Champlin case. And what I will tell you, unfortunately, and we can't talk about, we only talk about glorious victories where termination is upheld. The Bureau of Mediation Services doesn't allow publication of awards where the employer has simply gotten their decision overturned. So in this case, we'll talk about Coon Rapids that had one that was not quite upheld as a termination, but we can't talk about that. So here you go. Terminations for off-duty DUI are kind of gone both ways. We had a termination reduced to 30-hour suspension for domestic violence. Again, we can report about that because it's still discipline that was upheld. Veterans preference, we get a fair amount of these terminations. Now, this is a misconduct standard that winds up as the same as the just cause standard. Conviction or possession of a controlled substance, failure to advise the employer of a prior conviction, that will get you fired. Conviction of 5 charges involving breaking into an ex-girlfriend's apartment and failure to notify the employer. Off-duty use of cocaine. This case was actually very cool in terms of the cocaine use occurred off-duty, but it was at a garage where some people that owned a monster truck lived. So that case is very memorable to me. Again, Arbitrator Beffert. I think Arbitrator Beffert sometimes cringes when our law firm hires him because he knows some of his facts are going to be a little interesting. Termination of a plumber for DUI and open bottle resulting in the employer's insurer prohibiting veteran from driving the employer's vehicle. That's an interesting case. Termination of a child mental health worker arrested for domestic assault and later a DUI arrest. So with that, I have run over by 2 minutes, but I will gladly take any questions that you might have.
Scott, we do have one here. Should we try to negotiate language into our union contract about off-duty conduct? And if so, what should it say?
My recommendation when we start talking about off-duty conduct in union negotiations is it's a lot better to simply approach it from the perspective of union. We really need to have parameters that are covered outside of the union contract. And let's put these in the personnel policies, and we'll give you advance notice of what the changes of the personnel policies are. So if you negotiate it with the union, I would suggest you say, let's deal with this as the union agreeing to have our personnel policies apply. And then the personnel policies will detail what we view as off-duty misconduct or anything else that we can discipline for. Obviously, the union at that point always reserves the right to go back and say the union contract says just cause, and just cause is what we're fighting about. The personnel policies obviously get to be very important to us because when we go back to our just cause test, it's number one. It's the George Costanza. It's written down. It's what you can't do. So that's my recommendation.
We have another one here. If one of our employees writes a letter to the editor of the local newspaper criticizing the city, can we discipline them for that?
That's a pretty good question. Again, as city attorney, I've also been the subject of some letters to the editors that I'm not very good as a city attorney, or I believe my favorite one was questioning whether I was a citizen of the United States or had ever read the First Amendment. So as a subject of letters to the editor, I would tell you the key in this really gets to be if it's an employee that is simply signing their name as, Susie Smith from Andover, then they're speaking as a citizen, and they tend to have First Amendment rights that, by and large, we let roll off our backs. If they sign it as, disgruntled city employee, well, then all of a sudden they've got the action gets analyzed a little closer. And if it's action that they're complaining about that occurs in the context of their job, that gets us back to our disgruntled assistant district attorney, and we maybe can take disciplinary action against them.
And we have a social media question. What if we hear about an employee posting something on Facebook that is critical of their supervisor? Can we discipline for that? And how can we get the evidence in a legal manner?
That is the hot question that we've had since 2010. And basically, when we talk about employees criticizing supervisors on social media, in my world anyway, the protected activity flag goes up. And I want to take a real hard look at what the actual post is and determine whether it's something that's going to be a concerted activity. I'll give you an example on this. We've got an employee that posts on social media. Now let me give you an example of this if I can reach it. I'm never going to find it. The employee posts on their Facebook site that says, "I think our employer stinks. Their wages, their terms, the condition, and their supervisors are no darn good." And they didn't put darn in there. And they ended by saying, "Other employees, what do you think?" Well, all of a sudden you're talking about collective action because they're inciting the insurrection, but they're doing it through social media. It's protected collective activity. One of the reported cases that's really an interesting one that's not protected is the employee is, of course, on Facebook while at work, and they get reprimanded for not doing something. And rather than actually go do what the supervisors reprimanded them for not doing, the employee posts on their Facebook, "I think the supervisor just absolutely stinks," and, blah, blah, blah. Well, it's an individual gripe. At that point, you can take action against the employee. They're not engaged in protected concerted activity. So it's one of those areas, like I said, the National Labor Relations Board, their general counsel is going to spend the rest of their natural lives writing opinion letters and guidance on social media. And they're never going to stay ahead of employees' abilities to creatively irritate their bosses.
Well, thank you, Scott. That's all the time we have for questions. A recording of this webinar will soon be available on the League website, and we encourage you to check the website often and read the city's bulletin e-newsletter regularly to stay up to date on the resources available to you through the League. Thanks for joining us today. This concludes our session.